It's kind of funny. If you think about it, we are all basically playing this massive, incredibly complex multiplayer video game every single day.
Yeah, and just like any video game, there's this underlying code, right?
Exactly. A set of invisible rules that dictate exactly what you can and cannot do. I mean, you don't always read the terms of service when you boot up the game,
Oh, nobody does.
right? But those rules are running in the background, shaping, every single interaction. So, welcome to today's deep dive. Today, we are hacking the operating system of business.
We are indeed.
We're taking a masterclass in business law to uncover the invisible rules that govern everything from like buying a simple cup of coffee to executing these massive corporate mergers. We are talking about contracts.
Because when you look at the mechanics of contract law, you aren't just looking at, dry instructions on how to avoid lawsuits. You're actually looking at the foundational architecture of how society functions.
Yeah, it's the real nuts and bolts.
Exactly. For anyone managing a business, running an audit, or just balancing a ledger, contracts are the ultimate source of truth. I mean, they dictate how humans have agreed to allocate risk in commerce.
Which is huge. If you don't understand the contract, you literally don't understand the actual risk sitting right there on your balance sheet.
Precisely.
So today we are decoding that architecture. We're going to look at what actually makes an agreement legally binding, what happens when deals inevitably fall apart,
Which they always do.
right? And the very special set of rules that kick in the moment physical inventory starts moving across the country. But before we can talk about a deal going bad, we have to establish how a deal is born.
Yeah, we need to move from that abstract, kind of warm and fuzzy idea of two people shaking hands.
To the strict legal DNA of an enforceable contract. Because, as it turns out, not every promise is a contract.
No, definitely not. The legal definition we're working with here is that a contract is a promise, or a set of promises, for the breach of which the law gives a remedy.
Okay.
It creates mutual obligations that a court will actually enforce. And right off the bat, the legal world divides these agreements into two massive governing
Right,
bodies.
let's break those down.
First, you have common law, which covers services, real estate, employment, and insurance. Second, you have the Uniform Commercial Code, or the UCC.
The famous UCC.
Yeah, the UCC, which deals exclusively with the sale of tangible, movable goods.
Okay, but before we get to the special rules for selling physical goods under the UCC, there are four fundamental pillars required to build any valid contract, regardless of whether you're, I don't know, hiring an accountant or buying a warehouse.
Right.
So if I offered to paint your corporate headquarters and you accept, we have an agreement. Is that enough for a legally binding contract?
It's the
Oh, our listeners got something to share. Let's hear it.
Yeah, I got some news share. Yeah, I got some news share. Why don't you, before you go into talking about like this contract, like the like how it's valid, and
Oh,
how,
yeah, let's hear it.
yeah, like I'm saying, like how you get this like valid enforcement contract. Like, what does the two distinctive, what does common law and UCC have to do with contracts? Like, go into detail on that. Can you explain it?
That is a fantastic interjection.
Absolutely, it's a critical distinction.
Okay, let's unpack this right now because knowing which rules apply is everything.
What's fascinating here is that common law is the default.
Yeah, that's where most contracts began historically.
It's case law developed over time, and it bears contracts for services.
Ah, yeah, uh-huh.
Yeah, so like I think I have to look more into common law, but like where exactly in common law, like what does it mean? Like we talking about jurisdiction, which governs all these contracts. Like what exactly what
That is a fantastic interjection.
Absolutely, it's a critical distinction.
Okay, let's unpack this right now because knowing which rules apply is everything.
What's fascinating here is that common law is the default.
Yeah, that's where most contracts began historically.
It's case law developed over time, and it governs contracts for.
That is a phenomenal question about the source of common law.
It connects right back to that idea of jurisdiction.
So when we talk about common law in the U.S., we're generally talking about law that has developed from judicial decisions.
Right, it's judge-made law or case law. It's based on precedent.
So it's not a specific statute passed by a legislature.
It's the accumulation of rulings on services, real estate, and employment contracts over hundreds of years.
Think of it as law built from the ground up by specific jurisdiction state courts applying those historical precedents.
It sets the baseline rules for all contracts except where a statutory law explicitly steps in and changes it.
And that's exactly where the UCC comes in because it is that statute.
Oh, yeah,
okay, so like give me an example of common law, like a statute, as in like give me an example.
Oh, yeah. Uh-huh.
Give me an example of a common law. Like what from what book or like from what where like give me a name of a common law book or something. Like where from what entity.
That's a great question about finding a single source for common law.
It highlights the core difference between the two systems we're discussing.
See, common law isn't codified in a single book or statute like we might think of a federal law.
It's not one entity. It's the law that comes from all the accumulated court decisions over time.
Think of it less like a single rule book and more like a massive, constantly evolving library of judgment.
Yep, go on.
Then where is the library? Give me the name of the library of the thing. Like I don't understand. It's not codified into the federal law.
That's a great metaphor, the library.
It really hammers home that feeling that the law is somewhere.
When we use that analogy, the library is actually the sum total of all the court archives.
You'd be looking at centuries of state and local court opinions.
These are compiled into volumes called case reporters and legal treatises.
So if you were looking for the source, you'd be looking at these collections of judicial rulings.
But there is no single central common law book of contracts you can point to.
Instead, you look for the prevailing precedent within the specific state's jurisdiction for that contract type.
That accumulation of case law, the judge-made law, is the common law that sets the baseline.
Now, in contrast to that complex, evolving library, we have the UCC.
Because it is that statutory law, it's codified and much easier to locate.
That's the key distinction for today's topic, especially for business.
Precisely. The UCC, the Uniform Commercial Code, is a set of state laws.
Every single state has adopted it, which is the key point about jurisdiction here.
This creates a uniform set of rules for commercial transactions across state lines.
That consistency is essential for businesses dealing with tangible, movable goods across the country.
It's super.
Oh yeah, let's hear it.
Okay, so then what does the four pillars of a valid
Hey,
so,
yeah, what's up?
so what does the four pillars of a valid contract have to do with UCC or common law?
That is a phenomenal question, and it brings us right back to those four pillars.
Absolutely. Think of the four pillars: agreement, consideration, capacity, and legality as the absolute foundation.
They are the default rules set by the common law library that we just talked about.
Every contract, whether it's for painting a house or selling a shipment of furniture, must meet those four pillars.
Okay, let's unpack this. The UCC doesn't eliminate the pillars.
No, it assumes those pillars are present, but it modifies or relaxes the rules for certain pillars only when dealing with the sale of tangible goods.
Right. It makes commercial transactions easier and faster than common law would allow.
For example, the UCC is much more flexible on the agreement pillar.
Under common law, you need the mirror image rule, where the offer and acceptance must match exactly.
But under